extremely warm and cordial. It's very cold, so it has to be warm. Very warm welcome to the delegation from the Republic of Namibia. We're absolutely delighted to welcome you here with us. The delegation is headed up by the Honourable Dr. Albert Kawana, the Minister of Justice, and we have our dear friend and colleague, Her Excellency Ms. Sabine Bulke-Muller, next to me, who's the permanent representative of the state of Namibia here to the United Nations in Geneva. We'll be considering the second periodic report of the State Party, and so that everybody is apprised of how we'll proceed in this first portion of the interactive dialogue, we will be dealing with questions 1 through 14 of the list of issues. And we'll proceed in the following manner. We'll have an introductory statement by the representative of the State Party, and we'll then move on to have colleagues who will put their questions and concerns regarding the list of issues points 1 to 14, and then we will have a break to allow the delegation to organise their responses, and subsequently to their responses there may be follow-up questions put by colleagues in the committee. That being finished, we will begin the second portion of the list of issues. But generally speaking, this first section will take us until the end of the day. And so, without further ado, and reiterating our extremely warm welcome to the Namibian delegation for the review of their second periodic report, I have great pleasure in giving the floor to His Excellency. You have the floor, sir.
Thank you very much, esteemed Chairperson, distinguished members of the committee. It is an honor for me and my delegation to interact with the esteemed members of the committee. We are pleased that we submitted our second periodic report for review by this committee. The Ministry of Justice compiled the report with input from line ministries in consultation with non-governmental organizations, an umbrella organization for NGOs in Namibia. We are pleased that 2016 marks the 50th anniversary of this covenant, an anniversary that we shall all celebrate. Namibia pledges unwavering support for the initiatives planned for this jubilee, and we look forward to our participation. Mr. Chairperson, on behalf of my delegation, we stand ready to answer your questions and respond to your comments to the best of our ability, and they will provide written replies where necessary. Namibia was reviewed under the Universal Periodic Review in January this year, during which we had an opportunity to update the international community on the status of human rights situation in our country. 2 weeks ago, Namibia had an opportunity to interact with the Committee on Economic, Social and Cultural Rights on her recently submitted state report. Mr. Chairperson, during the past 25 years, Namibia has established a good track record of political stability, prudent macroeconomic management, moderate economic growth, and natural resource conservation. Unfortunately, the country continues to experience prolonged drought due to climate change. As a result, government efforts to address the interconnected problems of poverty and inequality in the country becomes even more difficult and challenging. Difficult and challenging because resources have been redirected to address the effects of drought. We are also aware that we are a developing country with limited resources. As such, there are genuine limitations in fully implementing obligations that we have assumed under various international instruments. Mr. Chairperson, it is our submission that political rights and economic, social, and cultural rights should enjoy equal treatment. It is further our submission that civil and political rights, without effective protection and promotion of economic, social, and cultural rights, will not bring about the desired outcomes anticipated by the 2030 Agenda for Sustainable Development, as articulated in the resolution, The Future We Want. Inclusive social development, environmental sustainability, economic development, and peace and security are goals that the Namibian government wants to achieve and maintain. Mr. Chairperson, we in Namibia believe that human rights issues are universal. They should not discriminate on the basis of color, gender, or economic origin, even economic continental origin. It is on the basis of this fundamental principle that our participation in the deliberations of the Human Rights Committee will be sincere, committal, and unqualified. Mr. Chairperson, I will now provide the committee with a summary of our reply to the list of issues, as well as an updated information on recent developments. In strengthening our institutional framework, the budget for the Office of the Ombudsman has been increased to enable it to investigate cases of human rights abuses and carry out awareness programs. The staff establishment of this office has been expanded to make provision for a division responsible for human rights education. As a result, the Office of the Ombudsman completed a draft white paper on the rights of marginalized communities and facilitated the process for the preparation and drafting of the National Human Rights Action Plan. This plan, which was adopted by government and indeed the Cabinet in December 2014, has 7 semantic areas. These areas are access to health services, access to justice, access to education, right to water and sanitation, right to housing, access to land, and the right not to be discriminated against. The Office of the Ombudsman in Namibia has been accredited in A status for 3 consecutive times. We are, however, aware of the recommendations made by the International Coordinating Committee of National Human Rights Institutions to further strengthen its autonomy. Mr. Chairperson, the overriding challenges Namibia faces today are to effectively tackle and overcome the problem of unemployment and persistent poverty of its citizens. The Namibian government has embarked upon a poverty eradication strategy, which is more ambitious than a poverty reduction plan. During 2015, we established the Ministry of Poverty Eradication and Social Welfare. Its mandate is to coordinate all programs aimed at eradicating poverty in the country. The percentage of people receiving social grants, such as disability grants, old age pension, and grants for orphans and vulnerable children, have drastically increased. We increased the social grants in 2015-2016 as well as 2016-2017 budget. The government is also aware of the impact of unemployment on the poverty levels in our country. We are happy to report that the Wage Order for Domestic Workers Regulations under the Labour Act of 2007 was passed and came into force on 16 December 2014. The regulations set the minimum wage and supplementary minimum conditions for employment for domestic workers. discussions are underway to introduce a national minimum wage in Namibia. Mr. Chairperson, among some of the pertinent issues raised by several UN human rights committees is the absence of a specific legislation criminalizing torture. I wish to inform you and the esteemed members of this committee that the Law Reform and Development Commission has completed a draft legislation which will be tabled in Parliament before the end of this year. The envisaged legislation defines the crime of torture as explicitly stated under the United Nations Convention Against Torture. Mr. Chairperson, Namibia continues to place great emphasis on the rights and welfare of children. To this effect, Parliament passed the Child Care and Protection Act in 2015, last year. The Act deals with aspects such as juvenile justice, adoption, and protection from harmful cultural practices, to mention but a few. Research conducted by both government and independent bodies indicate that female genital mutilation is traditionally not practiced in Namibia. Indeed, this phenomenon is not known in Namibia. The Act will soon come into operation since the drafting of regulations is almost completed. The first children's advocate in Namibia was also appointed in the Office of the Ombudsman. The Child Status Act of 2006 provides for the equal status of children born in and out of wedlock. To demonstrate our commitment to enhance access to education, the government in 2014 implemented free universal primary education in public schools. This has since been extended to secondary education in public schools this year. Mr. Chairperson, despite the existence of progressive legislation, the evil phenomena of violence against women and children remains a serious concern to the Namibian government. The government continues to work with all the stakeholders, including the local NGOs, to address this issue. Government has improved the support services for survivors of gender-based violence and increased awareness raising through the National Advisory Committee on Gender-Based Violence, which consists of cabinet ministers. We are currently in the process of reviewing the Combating of Domestic Violence Act with a view to increasing penalties. As I speak now, gender-based violence awareness activities are taking place in Namibia in all 14 regions of our country. Regarding gender equality, the government launched the revised National Gender Policy 2010 to 2020 in March 2010. Mr. Chairperson, currently Namibia is hosting 1,672 refugees, and this figure is likely to increase because they do arrive every day in our country, and asylum seekers. About 30 asylum seekers arrive in Namibia every month. The Namibian government approved a policy framework for local integration of refugees in Namibia and directed the Ministry of Home Affairs and Immigration to integrate the remaining 2,400 Angolan refugees into the Namibian society. The UNHCR country office closed its operations in Namibia in December last year. Support to refugees is now provided through the UNHCR regional office in South Africa. Lastly, esteemed Chairperson, there are a number of draft bills which are underway for tabling in Parliament. These include Customary Law Marriage Bill, Divorce Bill, and Child Justice Bill. We now, Mr. Chairperson, look forward to a constructive, interactive dialogue with the committee members. I thank you for your attention.
Thank you very much, Your Excellency, for your initial presentation. I think that leaves us ready to start the dialogue with the state. with questions coming in from colleagues. I already have a few on my speakers list, and without further ado, I'd like to give the floor to Mr. Sittlesing. You have the floor, sir.
Thank you, Chairperson. It gives me great pleasure to welcome this high-level delegation from Namibia, and it's always good to have the Minister of Justice heading a delegation because we know that country reports under the ICCPR are usually prepared or centralized at the level of the Ministry of Justice, since sometimes there are many legal issues which are involved. I shall be addressing issues numbers 1, 2, and 9. And as I said, since we have representatives from the Ministry of Justice, I shall be raising a few legal issues right from the beginning. In the first question that the committee put in the list of issues, we asked that the state party should elaborate on the status of the covenant vis-à-vis domestic law. Reference has been made time and again to section 144 of the Constitution of Namibia, which states that unless otherwise provided by this Constitution or Act of Parliament, the general rules of public international law and international agreements binding upon Namibia under this Constitution shall form part of the law of Namibia. So we understand, therefore, that Namibia has a monist system, and that consequently our own covenant would, to that extent, form part of the laws of Namibia. Yet, an act of parliament can invalidate obligations undertaken, and can also invalidate international agreements or treaties. This derogation can sometimes put at stake commitments taken on the international level at any point in time. And this concern was expressed when Namibia presented its periodic report on the last occasion, and was reflected in the concluding observations of the committee at that time, which is why this issue has been raised anew. So could this confusion be cleared again about the status of the covenant in the domestic law of Namibia? Secondly, under the first issue, we asked whether the state could provide information about a mechanism which has to be established to implement the committee's views adopted under the optional protocol. Since it would appear, and do correct me on this if I've got it wrong, it would appear that the views of the committee in the case of Mueller, dating from 2000, which concerned a matter of names, whether these were not accepted by the state. You have mentioned in paragraph 8 of your replies to the list of issues that the issue was properly addressed by the Supreme Court in Namibia. And you also seem to indicate in paragraph 7 that there is no need for a mechanism to implement the committee's views following a communication under the optional protocol. So does it mean that although the Human Rights Committee finds in favor of a complainant following a communication, that complainant has to enter a fresh case before the courts in Namibia to enforce his rights under section 25(2) of the Constitution, which again has been referred to. Is this what happened in the case of Mueller? So if there is a misunderstanding concerning this issue, it would be appreciated if you would clear the matter. have mentioned in your opening speech the law to amend to amend the act concerning no, you reference you have said in your speech, excuse me, that there will be that the ombudsman has been given the powers has been that a child protection unit or a person having certain powers to look after the rights of children has now become part of the ombudsman office. It would appear that when it comes to the powers of the ombudsman, he has been allowed to extend his jurisdiction to economic, social, and cultural rights, again by virtue of Section 144 of the Constitution, whereas the Ombudsman Act of 1990 limits his mandate to civil and political rights. It is good that he has been allowed to do so, but now he has proposed certain amendments to his own act, and could you please inform us about the status of these amendments as to whether they have been accepted by the state, and as mentioned in the replies to the list of issues, you have said that he would like this to be clearly defined in law, that economic and social and cultural rights should be part of his mandate, so that he has as broad a mandate as possible, and that he should also be given the right to visit places of detention to see to it that no human rights violations are taking place in these places of detention. Furthermore, the Ombudsman has suggested that he should be given the powers to recruit his own staff as provided by the Paris Principles governing the status of human rights institutions. And on the same point, just to be fully compliant with the Paris Principles, the Ombudsman should have full control over his budget. So, as I've said before, could you enlighten us on the status of this request? Have they now been submitted? Do they now form part of a bill that is going to be submitted to Parliament, or are these just at discussion stage? And so that the Ombudsman is fully compliant with the Paris Principles. I shall now turn to issue number 9, concerning the rights of persons with disabilities, and in the replies to the list of issues, a number of important pieces of legislation has been set out to show that the rights of persons with disabilities are adequately protected, but at the same time, the replies quite candidly mention that insofar as the Labour Act is concerned, I take it that under the Labour Act, employers are required not to exercise discrimination in the recruitment of persons with disabilities. It has been stated that enforcement in this area was ineffective and societal discrimination persisted. Could you give us further details about this, and as to what are the difficulties in enforcing the Labour Act to get employers to at least to have a certain proportion or even a small proportion of their workforce recruited amongst persons with disabilities, which is now a measure adopted in many countries, especially after the Convention on the Rights of Persons with disabilities has come into force to show to the public that persons with disabilities have to be included in society at large and do not have to be treated as persons who should be excluded from society. You have mentioned that there is an Affirmative Action Act. So could this be used to encourage employers, both in the public and the private sector, to employ a certain number of persons, as I said, and this could be enforced by law? So why is it that the Labour Act is ineffective? Do you intend to have enforcement officers to see to it that its provisions are enforced? You have a National Disability Council, but however, it is mentioned that between 2004 and 2013, that is over a period of 9 years, only 22 cases of discrimination have been registered. Is there an explanation for that? Could it be that persons with disabilities have not been fully informed about their rights? And is there a program to make them aware of their rights and to sensitize them to the rights of persons with disabilities? So at this stage, I would be grateful for the replies of the delegation on these issues I've raised under questions numbers 1, 2, and 9. Thank you, Chairman.
Thank you very much, Mr. Stulsing. Now I pass the floor to Mr. Boussid. You have the floor, sir.
شكرا سيد الرئيس. اسمحوا لي سيادة الرئيس في البداية.
Thank you very much, Chairman. First and foremost, allow me to extend a cordial welcome to the high-level delegation from Namibia. I'd like to thank the delegation and the head of delegation for the introductory statement that was made at the beginning of the session and for the information that have been provided and are going to be provided. I'm responsible for issues 6, 8 and 14, and the first relates to legislation which includes discriminatory elements and the question of guaranteeing non-discrimination in practice. We have asked for questions to be answered relating to non-discrimination of women. We see that some legislation is not complied with because women are discriminated against when it comes to loans, to wages, to ownership of property, education, etc. Now, if we consider the answers provided by the States Party, you state, then the Ombudsman has put in place a national human rights action plan, which began to be implemented in December 2014. And this is a plan of action which puts the fight against discrimination against women and the disabled is placed front and center. And it is also a plan which provides for bills on discrimination on the grounds of gender and ethnic group. And it does fight discrimination. It's also a plan which aims to ensure that there is better equality and that it deals with cases of discrimination. And there are allocations and financial provisions for compensation. So my question is, this is all at the legislative level, but is it implemented in practice? And the new legislation that has been adopted on non-discrimination, is this legislation fully implemented and updated? I would also ask for an answer to a question on discrimination against women when it comes to loans, wages, housing, etc. Now, issue number 6 relates to measures taken to combat discrimination and afford people living with HIV and AIDS with protection, particularly when it comes to employment, while acknowledging that women are disproportionately affected by this virus. We would also like more information about the alleged practice of forced sterilization. You've given a very detailed answer to the question, have told us about the efforts underway in the state party to protect this category of persons against discrimination. And we are talking here about people living with HIV and AIDS. Very real efforts are being made by the country, and we must pay tribute to that. You have, for example, redoubled your efforts to try and ensure that people living with the condition have access to care and don't have to travel very far to reach healthcare centres. And it would appear that 80% of people living with the condition do have access to care. Nurses and healthcare staff have been trained to provide care for this category of person in the healthcare centres, and the law provides for non-discrimination or prevents discrimination of any kind to persons living with a condition. And assistance is also provided by NGOs. Now, you say nothing about forced sterilisation in your answers, however, and you also do not tackle the question of the truthfulness of allegations in this respect. So we would like to ask you more about the situation. And can you also tell us more about voluntary sterilisation? In other words, with the consent of the person concerned, what measures have been taken to ensure that appropriate consent can be sought? Now, on question number 8, this relates to the LGBT community and the discrimination that they suffer. You say that in Article 10 of the Constitution, discrimination on the grounds of sex and gender is prohibited, and that you have no reported case of harassment, that none has been reported to the Ombudsman. And the government believes that this is simply not a phenomenon in the country, because it is actually something that happens in the private sphere. You also say that the government does not intend to amend legislation in this respect. So my question is this: how do you respond to the report which alleges that there are discriminatory practices against the LGBT community? And finally, to come on to my last question in this cluster, this is number 14, which contains 6 subsections, actually. First of all, the presentation of information on the law against torture and the question of the definition of this phenomenon. Secondly, the courts that have not received any evidence on 12.1, the article of the Constitution on torture. Thirdly, the reports that mention the use of force by law enforcement and police officers, and information that police officers are arresting sex workers and obliging them to have sexual relations with them before they are released. We've also asked you to provide examples of cases of torture and rape by police officers and measures taken to ensure the independence of the police force. We've also asked for clarifications on guarantees put in place to ensure that the internal police investigations, or that the authorities investigating police conduct, are independent. You only provided answers relating to the issue 1 on the draft bill on torture. You simply said that this would be submitted to Parliament at the beginning of 2016, and you defined torture, which we find in a paragraph of the bill. But in your introductory statement today, you told us that this is a bill which would in fact be put before Parliament at the end of the year rather than the beginning. So we wonder why this should be so. Finally, on the 5 remaining sub-issues which I've mentioned, I would ask for answers from the delegation because these are questions of the utmost importance. Thank you, Chair.
And thank you very much, Mr. Boussid. Now I pass the floor to Ms. Basartzis. You have the floor, Madam.
Thank you, Mr. Chairman. I would like to add my welcome to the distinguished high-level delegation of Namibia for the dialogue in relation to its second periodic report. The committee thanks the State Party for the submission of the report, as well as for the replies to the list of issues. My comments and questions this afternoon will address issues number 4 and 5 of the list of issues. Issue number 4 contains a cluster of questions relating to concrete measures taken to combat discrimination in the field of customary marriages and inheritance. The committee asked Namibia to indicate measures taken to encourage the registration of customary marriages, to specify measures taken to eliminate legal and cultural discrimination faced by women under customary law, to provide update information on the status of the enactment of the Bill on Recognition of Customary Law Marriages, and a series of other questions which will follow. Now, the committee welcomes the development of the National Human Rights Action Plan adopted by the government in 2014. It was brought up by the distinguished head of delegation and addressing the thematic area in the right of non-discrimination. However, it appears that concrete measures in the form of legislative reforms are still delaying. Now, we acknowledge the State's Party reply that in accordance with Article 66(1) of the Namibian Constitution, both customary and common law, which enjoy equal status, applicable at the date of independence are still standing, as long as they do not contradict the Constitution or civil law. Now, what about concrete legislative measures and reforms? In its responses, the State Party notes that the Bill on Recognition of Customary Law Marriages is in the process of consultations since 2004, when it was initially tabled. I noted in the opening statement by the Honorable Dr. Albert Kawana that this is one of the bills underway for tabling in Parliament. But could the State Party provide more precise information about the exact status of this bill? When will it come into force? Because there are concerns raised by civil society about the continuing lack of a system of recording customary marriages, concerns about polygamy, grounds for customary divorce, which would seem to discriminate between men and women, and customary divorce procedures which inadequately protect women and children. Now, pending the adoption of the bill, what are the measures, if any, that have been taken to encourage registration in practice of customary marriages? And have there been any concrete measures to eliminate, if not legal, but cultural also, discrimination faced by women married under customary law? Could the State Party specify whether and how the implementation of Section 26(2) of the Communal Land Reform Act 5 of 2002, allowing for appeal against decisions made by statutory institutions, is monitored? There are reports that traditional practices permitting family members to confiscate property of deceased men from their widows and children continue. Does the State Party have any intention to review the Native Administration Proclamation 15 of 1928, regulating marriage and inheritance matters under customary law on the basis of race? While the Namibia High Court has declared that Sections 18(1) and 2 and regulations made under Section 18.9 are in conflict with the Constitution, notably in the case Berendt versus Sturm in 2003, the High Court stated that the proclamation is deemed valid until this defect is addressed. Now, it appears, according to reports, that despite the adoption of the Estates and Succession Amendment Act in 2005, race-based practices continue to apply. So the committee would appreciate some clarifications on this issue, as the replies do not seem to give adequate responses in this regard. And in this connection, I would like to add to another question: what is the status on the draft intestate succession bill, which will apply only one set of rules on intestate succession for persons of all races and provide improved protection against property grabbing? There are concerns here again raised by civil society that consultations on the adoption, the actual adoption of this bill, are moving quite slowly. I turn now to issue number 5 on children born out of wedlock and inheritance and or de facto discrimination towards these children. The committee recognizes here that there are legislative provisions. The state mentions the Children's Status Act number 6 of 2006, by which all children are to be treated equally in terms of inheritance from parents. It also recognizes that there are some Supreme High Court decisions, in particular the Lot of France versus Paschke case, which was of extremely high profile case in this area. But there are still unofficial reports of cases where such children, namely children born out of wedlock, are being denied their right to inherit in practice. Is State Party, first of all, aware of such practices? Does State Party have actual data in this regard? And are such cases where children are being denied their right to inherit reported? And if not, could this be due to the lack of awareness of the legal provisions in place? And a further question on this, in this field, is the Child and Protection Act 3 of 2015 in force? Is it expected to come into force? And when would that be? I would appreciate some precisions to this effect by the State Party. This concludes the questions I have for this afternoon. Mr. Chairman, thank you very much.
Thank you, Ms. Basartitz. Thank you very much. Now I turn the floor to Sir Nigel Rodley. You have the floor, sir.
Thank you very much, sir. And like my colleagues, I warmly welcome, I guess in my case, welcome back a delegation from the State Party. And I'm looking forward to the dialogue. Before I start on a number of questions that I want to focus on, there's just one that isn't on the list of issues that I would like to raise with the delegation. It's not in order to ambush it, but to give it time to think about it. And that is something related to, I guess, constitutional and legal framework, issues 1 and 2, but only vaguely related. And that's to say the termination, the dissolution of the Southern African Development Community Court, the SADC Court, the tribunal. This committee traditionally encourages states to find remedies in relation to possible human rights violations at the regional level and through various kinds of bodies, not just necessarily at the national level. And it always seems like a step backwards when a remedy that might exist is terminated. relation to this particular tribunal after a decision in 2008, a property rights case relating to another country, another member of the Southern African Development Community, which that country clearly wasn't very pleased with. Eventually, 4 years later, after first having had its right to receive individual petitions terminated, then the whole tribunal was terminated. I wonder if the state party would like to comment on why it went along with the decision to terminate that particular tribunal. Now to the issues that are clearly before the state party. First of all, issue 7 and the issue of abortion. And let me start out by saying that I'm grateful for the responses, and on balance, it seems like the various grounds that the state party's legislation does acknowledge as grounds for a lawful termination of pregnancy would fall very much within the kinds of categories that this committee thinks are important to recognize as such grounds. There's one that I find a little difficult to plumb, and maybe the state party can help me on that. The final one mentioned in paragraph 41 of its responses, that say a termination may be lawful when the fetus has been conceived in consequence of illegitimate carnal intercourse and the woman is, owing to a permanent mental handicap or defect, unable to comprehend the implications of or bear the parental responsibility for the fruit of coitus. So far, so good. Do I understand from that regardless of the issues that might conduce to what might otherwise be a lawful termination, if there's no permanent mental handicap or defect, or if the person is able to comprehend the implications of or bear responsibility for the fruit of the coitus, then they are not entitled to a termination of pregnancy, even if the other factors that would normally justify a pregnancy are in place, such as threat to the life or health of the woman. I have to say that it has been put to us by civil society that is the case, and that judges will not authorize a termination of a pregnancy that has been incurred by unlawful intercourse. Is that correct? Carrying on, the answer very helpfully in paragraph 42 describes the procedure, or at least part of the procedure, for an abortion to be authorized. First of all, there has to be the woman's doctor, and then 2 other doctors are required to certify the existence of the grounds for an abortion. And then the operation must be performed by a medical practitioner in a state hospital or an approved medical facility. Now, I'm not a public health expert, and so I wouldn't know the statistics, but I suspect that there probably aren't more doctors per 100,000 population in Namibia than there are in the UK. And I have to say that hurdles like that to overcome in the UK would be very difficult. To find 3 doctors, to go around to find 3 doctors, all of whom are going to certify that the relevant conditions are there, some of which probably require substantial medical examination. And understand, which isn't mentioned in the response, there has to be a judicial authorization for the termination of the pregnancy. Is that correct? And if then there has to be judicial authorization after all of these medical hurdles have been gone through, and then it has to be done by a doctor, it seems to me that that might take a bit of time, bearing in mind that it can take 2 or 3 months for a person to realize that they're pregnant. And yet I understand that there is a practice in the medical profession in Namibia according to which doctors won't perform abortions anyway after the first trimester of pregnancy. Is any of that wrong? And if it's not wrong, if it's correct, it does seem that the assertion that the procedures are cumbersome almost to the point of unavailability. It's as though what is being offered with the one hand is being taken away with the other. And this seems to me to be consistent with a word I have discovered, or a term I have discovered in the course of preparation for this discussion, which is baby dumping. Apparently this is quite a well-known issue in Namibia. It was new unto me, but it is apparently the business of fetuses and sometimes live births, live babies, being simply disposed of. And is there that problem? And if there is that problem, isn't it at least reasonable to assume that that may have something to do with the de facto difficulty of obtaining a lawful pregnancy, a lawful termination of pregnancy, excuse me. I noticed that we did ask the question inviting the state to comment on reports according to which a high number of girls and women resort to unsafe abortions, and on the frequent incidents of killings and abandonment of babies and infants. Please elaborate on the measures taken to provide support to young and single mothers and protect them from discrimination and stigmatization. None of that was responded to by the state party. The state party merely said it had no intention to amend the current law on abortion. I hope I can imply the word present in front of intention, and then that as a result of this discussion, if my understanding of the facts is correct, they may review their intention. But meanwhile, it would be helpful to know, this is something that doesn't require any change in legislation, to know what measures are being taken to provide support to young and or single mothers to protect them from discrimination and stigmatization. Obviously one way of avoiding the need for abortion in the first place, and the need for termination in the first place, is if contraception is available. And it's not clear to me from the response to question to the third part of issue 7 whether or not there is access to contraception by young people. Apparently they can, people, if they're at least 14 years old, can consent to medical treatment. Does that mean that they do then have access to contraception? I think of various forms of contraception that may or may not meet the definition of medical treatment. If it is not achieved through medical treatment, depending on the definition of medical treatment. Does that mean then that essentially the younger they are, the less likely they are to be able to have access to a lawful termination of pregnancy? And is that, if that's true, what would be the policy reasons for wanting to inflict pregnancies on people who are too young to consent to medical treatment? But maybe I've misunderstood it all, but it wasn't clear from the response in paragraph 43, and perhaps perhaps if that paragraph can be elaborated on, my concern in that respect would be dispelled. Let me now move on to paragraph 12, to issue 12 of our list of issues. And let's start with the question of harmful practices against women and girls and various kinds of initiation that are mentioned in issue 12. I'm not going to go through them all. The response of the state party is that most of the alleged harmful practices against women cited by the committee aren't practiced in Namibia, judging from the words or terminology referred to by the committee. And then it refers to one which seems a little bit far-fetched in the local language of Zambia. And the other practices are not harmful at all. Well, most of the practices mentioned there clearly are harmful. It would be good to believe that they don't exist in Namibia, but according to UNAIDS, gender-based violence in Namibia, according to the publication of the state party's own Ministry of Gender Equality and Child Welfare, its report on public participation in law reform revision of Namibia's draft Child Care and Protection Bill, according to the Legal Assistance Center and UNICEF, most of the practices do exist in Namibia and weren't invented by this committee. But apparently they may largely exist in one part of the state party, I've discovered recently, namely the Caprivi area. And I would be, where they do indeed speak Loza, which is, I gather, the Zambian language. So it would be helpful to know if those practices really do not exist, even in the Caprivi region, and if so, it would be good for the state, for the delegation to explain why all these really quite responsible sources say that they do. Yes, the issue of female genital mutilation. After some further consultations, I'm disposed to accept the state party's affirmation in paragraph 59 of its list of responses, according to which research conducted by both government and independent bodies indicate that female genital mutilation is traditionally not practiced in Namibia, which is very reassuring. Though it would be good just to, if we could just dot the I's and cross the T's by having some specific references to what that research may consist of. The issue of, now list of issue 13, the last one of mine for this afternoon, Mr. Chairperson. That is the question of rape. And there's no argument that it's unlawful, and the state party is committed to investigating it and doing something about it. Both there's the law and the National Action Plan. The particularly interested in knowing, and the list of issues in response to our question about measures taken to investigate allegations of rape, it basically mentions the law and some of the activities of the Ministry of Gender Equality and Child Welfare. The and basically trying to protect vulnerable witnesses. But it would be useful for us to know, in addition to that, which monitoring strategies to improve police investigation of gender-based cases are being carried out. The National Action Plan, which is referred to in the state's report, not the responses, but the report in paragraph 63, refers to quite a number of procedures that should have been in place to improve the performance of what were then called the Women's and Children's Protection Unit. I believe it's now called the Gender Violence Unit. New systems were to be rolled out between 2013 and 2015. Any updated information on how far that plan has been implemented? The Gender Protection Unit, yes. And yes, it would be useful for us to have information on whether another part of the National Action Plan, paragraphs 126 and 127, mentioned in paragraphs 126 and 127 of the State Party's list of issues, responsive to the list of issues, how far they are being implemented with respect to specific measures to reduce case withdrawals, in particular through measures related to bail hearings, information about victim compensation through the Criminal Procedure Act, and support from traditional leaders. This is Strategy 17 of the National Action Plan. And we're getting there, Mr. Chairperson. Still on 13, we asked for statistical data on sentencing in rape cases disaggregated by the number of cases heard by court, the type of court, civil or traditional, hearing the case, the sentences imposed, the number of defendants acquitted, and the number of rape allegations withdrawn. And I see no reply to that part of our question, and would appreciate receiving that information. We've asked for the number of cases where the various remedies referred to relating to the conditions that have to be met for an employee who leaves his or her job owing to sexual harassment to be entitled to remedies. We're told about remedies in the list of issues responses, but not the number of cases where these remedies have been awarded. So are the remedies available and accessible in practice as opposed to just being on the books? And with that, Mr. Chairperson, I think I can relieve you, the committee, and especially the delegation of any more importuning from me on these issues, though I'm afraid I will be coming back later on a couple of other issues. Thank you very much.
Thank you very much, Sir Nigel. And now I turn the floor and the attention to my dear colleague, Ms. Sarah Cleveland. You have the floor, madam.
Thank you, Mr. Chair, and I would like to extend a very warm welcome to the Minister of Justice, Dr. Kawana, and the delegation from Namibia. If I could be allowed to reminisce a moment, in the summer of 1990, I had the privilege of spending the summer in Namibia as part of a human rights study mission looking at the transition to independence and the implementation of your new constitution. So I have been pleased to watch your evolution ever since then with interest, and it's a great privilege, in particular for me, to be able to be part of this dialogue. So welcome. I'm responsible for addressing issues 10 and 11 today, both of which address issues relating to gender discrimination and gender-based violence and domestic violence, and which overlap to some extent with questions that my colleagues have already raised. With respect to issue number 10, we asked for information regarding the number of women employed in the public sector, including in high-level positions, and for information regarding the wage gap in employment between men and women. You provided us with some statistical information relating to this issue, and we also received relevant information from other sources. But my first question is whether you could advise the committee what statistical information regarding the gender balance and the wage gap in employment the state party collects with respect to both the public and private sectors, and where this information is reported. On the substance, despite your laws regarding equal wages for men and women, a UN Women's study of last year showed that there is a gender pay gap of at least 16%, at least as recently as 2013. And according to media reports, your Deputy Minister of Labor responded to this report by indicating he would investigate the situation. I therefore would appreciate it if you could give us information regarding what investigation took place, what it disclosed, and what, if any, further actions will be taken based on those findings. More broadly, what initiatives are being undertaken by the state party to eliminate the existing gender wage gap? In July of last year, CEDAW expressed concern at the continued occupational segregation between men and women in the labor market and the low representation of women in managerial positions in the private sector, and recommended that the state party strengthen efforts aimed at eliminating structural inequalities and occupational segregation, in addition to improving the representation of women in managerial positions in the private sector. So could you please explain to the committee what actions have been taken or are contemplated by Namibia in response to this recommendation? Furthermore, compared to the relatively successful improvement of the representation of women in the public sector, there appear to be far fewer women in executive and senior positions in the private sector. So can you address what policies and programs are in place in addition to the laws you identified in your submissions to specifically advance the representation of women within executive and senior managerial positions in the private sector? In your reply to the list of issues for CEDAW, you stated that there has never been a case in the judiciary that addressed gender-based discrimination, which led me to speculate, given the consistent gender pay gap and underrepresentation of women in managerial positions, that this fact may suggest not that there is not a problem, but that women may lack sufficient access to information or sufficient means to raise the issue of employment discrimination in the judiciary. I therefore would appreciate it if you could explain the efforts that the state party has taken to educate the general public about the problem of gender discrimination in employment, to establish and publicize easily accessible complaint mechanisms, and whether or not free legal aid is available to women who seek to pursue such claims in the courts. Turning to issue 11, with respect to violence against women and domestic violence, I will apologize in advance. This is a lengthy and multifaceted issue. That apology is perhaps mainly directed to my chair. But I have several questions arising with respect to this cluster of issues. First, I want to thank you for your written responses and for the information you provided about the revised national gender policy in your opening remarks. Your written response to this issue focuses primarily on the outcome recommendations of the 2014 National Conference on Gender-Based Violence, which included recommendations to improve and streamline the process of reporting cases at police stations, to make the procedures more victim-friendly, and discourage the withdrawal of gender violence cases. Taxing of alcohol, incorporating prevention of gender-based violence into tertiary education, and engaging the Council of Traditional Leaders for their assistance in combating gender-based violence. I would appreciate it if you could inform the committee what steps have been taken in practice to implement these recommendations coming out of the conference into state law and practice. With respect to enforcement of the Combating of Domestic Violence Act, information before the committee suggests that there are insufficient gender-based violence protection units in the country, that these units lack adequate financial resources and support, and that access to assistance for women experiencing domestic violence, particularly in rural areas and particularly for indigenous women, is extremely limited. It has been reported as well that women have difficulty applying for protection orders due to procedural difficulties, lack of victim support and shelter, and physical distance from the magistrates, who are the only actors, as we understand it, empowered to issue protective orders, and that this is particularly true for San and other indigenous women and women in rural areas. Therefore, what plans do you have to expand access to your gender-based violence protection units and to ensure that they are properly resourced? How many shelters are currently operating in the country, and what is their capacity, and do you have plans to expand them? Given the 2014 Directive on Gender-Responsive Budgeting, does your national budget contain a specific dedicated allocation for gender protection units and their related staffing, training, and provision of shelters and other measures? And if so, what is that budget? What steps, if any, have been taken to facilitate the ability of women to access and obtain protective orders, including in rural areas? Specifically, what steps have been taken or planned to simplify the application process for protective orders, to authorize persons other than magistrates to issue protective orders in communities that lack a magistrate, including circuit courts and community courts, to provide for applications for protective order outside court hours or court days, since violence can occur at all hours, not just 8 to 5 on weekdays, and to make protective orders available for abuse in context of same-sex relationships. Concerns have been raised regarding non-enforcement of protective orders when they are violated, and release on bail of persons who have committed repeated acts of gender violence, including rape and threats to domestic violence victims, when those persons actually pose a danger to individuals and to society. Could you please therefore inform the committee regarding the circumstances for granting bail to perpetrators of domestic and gender-based violence, of the procedures that are followed for enforcing protective orders when they are violated, and importantly, the measures that are taken to protect women when violations of protective orders are reported or when persons subject to protective orders are released. With respect to our question in the list of issues regarding training for law enforcement officials, judges, and prosecutors. We understand that a gender sensitization curriculum was introduced into policy training centers on how to handle domestic violence and other gender-based violence issues. Could you please tell us the scope and content of this training program and how many police personnel have been trained to date? Could you also advise us what efforts are taken to train judges, prosecutors, and personnel in the gender protection units regarding sensitive responses to gender-based violence victims? And more broadly, what efforts are being taken to educate society at large, particularly men and boys, regarding domestic and gender-based violence? Civil society reports that 542 cases of domestic violence were reported between February 2012 and February 2013, including 30 cases of attempted murder and 24 cases of murder. I would welcome your reaction to the accuracy of this information and whether you, as the state party, collect similar data. And more generally, could you inform the committee regarding what steps you have taken to investigate domestic violence cases resulting in murder or attempted murder, and what the outcome of those investigations has been, including prosecutions that have been brought and any convictions secured? It's reported that a third of rape victims in the country withdrew court cases due to receiving compensation from the accused, succumbing to family pressure, succumbing to shame or threats, or as a result of discouragement at the length of time involved in prosecuting a case, and that as a result, only 18% of arrested suspects are convicted as a result of that and other factors. To the extent that there's a substantial gap between rape cases that are reported and those that ultimately result in conviction and prosecution, what steps are being taken to address this issue? And now I will address a few issues in our issue that were not addressed by the state party. We asked a question regarding whether your law recognizes mitigating excuses or defenses for violations taking place within a domestic relationship. And I would reiterate that question and welcome your response. It's not clear to me reading the face of your law that it does actually provide for mitigating excuses or defenses in this context, but I would appreciate the clarification. We also did not receive a response to the question regarding elimination of the practice of paying lobola or a bride price. We note that media reports that this practice contributes to domestic violence because women often find it hard to exit their marriages due to their inability to repay the bride price despite spousal abuse. We also note that while the bill on customary marriages would outlaw polygamy, we understand that lobola will remain legal. Our question, therefore, is have you considered rescinding this practice or rendering it illegal? And more specifically, what measures are being taken to ensure that women are not hindered from exiting or seeking protection from abusive marriages by the lobola? Finally, so-called passion killings were a subject of this issue in the list of issues, and they continue to be reported. It's our understanding that an increase in intimate partner killings, in fact, was one of the motivations for the Second National Conference on Gender-Based Violence. I therefore would welcome your response on what measures are being taken to combat so-called passion killings. And that concludes my question with respect to this group of issues. Thank you.
Thank you very much, Ms. Cleveland.
And the last speaker on my list is my colleague Olivier de Fruvel. You have the floor, sir. Thank you very much, Mr. Chairperson, and in my turn I'd like to wish a very warm welcome to the Namibian delegation and thank them for their report and their answers given up to the moment to the list of issues. I'd like to add 2 points to those raised by my colleagues. First of all, in the report, the State Party mentions allegations relating to mass graves discovered in 2008 and 2009 in the Caprivi region. These mass graves allegedly contain bodies of people targeted by attacks by the security services between 1994 and 2003. And this case related to the case of Mr. Faustinus Dictua. The State Party says that this was subject to inquiry, but I cite paragraph 34 of the report. To date, no evidence has been produced. I wonder, given that the report dates back somewhat now to the 23rd of February 2015, whether or not there is an update that you could provide us with regarding the inquiries underway. Have the mass graves been identified, located? Have they been exhumed? And have their remains been identified and returned to families? And whether or not any of those responsible have also been tracked down? My second question, according to allegations we've received during the period of the War of Liberation, around 2,000 members of the South West African Peoples, or its armed branch, were accused of espionage and as a result were detained apparently and tortured, and a certain number were subject to forced disappearance. Many of these apparently died in secret places of detention called Swapo dungeons. And it seems that to date no measures have been undertaken to look into these enforced disappearances. The disappeared victims have not been identified or located, and the responsible people have not been brought to justice. I wonder if you could provide clarifications on the measures undertaken by the State Party to describe how justice has been pursued and how reparation has been made to the victims. Thank you very much, Mr. Chairperson. Thank you, Mr. de Fruvel. Good. So that concludes our colleagues' interventions. We've put a great number of questions to you. We've raised a great number of different issues. We're going to give the delegation some 15 minutes until 4:45 to allow them to prepare the order in which they will respond. Of course, that information can be fleshed out subsequently in writing. At the end of the State Party review process, there's 48 hours where complementary additional information can be provided, because it's very often extremely complex for States Party to respond to such a wide range of questions in so little time. So there is that possibility open to you, but we're going to nonetheless take the break now, and the State Party delegation has at its disposal the adjacent room, which is laid out here for you to comfortably work on your responses. And so the meeting is adjourned until 4:45.